So, like any good moderator, I want to take this opportunity to make the panel all about myself. So, bear with me.
Good.
A couple of years ago, I wrote a PhD about the innovation defense in antitrust law. Spoiler alert, I did not manage to reinvent the wheel. However, I did at least come to realize that the relationship between competition and innovation and competition enforcement and innovation is complicated. Now, if we fast forward a couple of years to today, I read with great interest in the Draghi report that we should introduce an innovation defense in Europe. And I see that too in Teresa Ribera's admission letter. And to them, I have only one thing to say, which is good luck. But maybe I'm being a little bit too pessimistic. So we have here a fantastic panel to talk about this issue of innovation and antitrust, and then also about regulation and innovation. So what we'll do is we'll first have a presentation by Ginger Zhe Jin of the University of Maryland. She's going to talk about the slogan that that concentration chokes innovation. And then we'll have a second presentation by Richard Gilbert of Berkeley about the innovation defense, and also the slogan that he chose is creative destruction. So actually going way back in time. I think it will be fascinating. And then if we have time, we'll also talk a little bit about the link between regulation and innovation, and particularly ex-ante competition regulation and innovation. Ginger, the floor is yours.
Thank you, Dirk.
And
Did you
about
hear me
industrial
okay?
policy?
Sorry?
Industrial.
We will talk about industrial policy.
Could you hear me okay? Yes. Okay, yeah. Thank you, Dirk. Thank ICLE for organizing this wonderful event. I'm an economist, so I'm just going to talk a little bit about economic literature related to concentration and innovation. So economists has long been obsessed with the relationship between market structure and innovation. But before we dive into the empirical relationship between the two, I just want to mention a little bit about the firm's incentive to engage in innovation. I'm going to operate under the assumption that firms are self-interested, rational, and forward-looking. Okay, so that means if they decide to engage in innovation, they must have been expecting the economic return to exceed the cost they have to incur to do such innovation. And this calculation could be different from the social planner's calculation because the firm only cares about the return they can get from the innovation and the cost they incur. Okay, so that means if, let's say, the return that this individual firm expects from the innovation is lower than what the social planner is expecting, then the firm might be underinvesting. So for example, internet is a great technology, but it may be very hard to harvest all the convenience and benefits of internet technology to one firm. So that means the firms who are positioned to invest in such a discovery may underinvest, and that's why basic science has been supported by National Science Foundation and other kind of government agencies. And there's actually an analogous story with regard to competition. So if a new product can be very easily copied, and that means the competition could actually dissipate the economic return from such innovation to the extent that the variable profit may not be enough to cover the fixed cost of doing such innovation, which is going to hamper the incentive of invest in this innovation. And this tension is particularly acute if the innovation requires a large amount of fixed cost, but marginal cost is zero, right? If the competition, everybody has access to this technology, let's say because of the weak IP protection, then the price can be quickly drive down to marginal cost, which is close to zero. That means the profit may not be enough to cover the huge fixed cost. So this example means what? Means concentration actually could promote competition, partly because a monopolist may expect a bigger share of the benefits to reap to his self-interest, and partly because the competition may not be too intense to dissipate the variable profit. However, there's also a perverse incentive for a concentrated monopolies. And that's because the innovation product may end up to be a close substitute to the existing product. So the incumbent will have less incentive to invest in this new product just at the cost of its own product. This is a well-known cannibalization problem. Well, a newcomer into this industry may not have that burden, right? They can steal the market share from the incumbent, and therefore that return may be enough to cover the cost of innovation. So the newcomers may have more incentive to engage in such innovation than a monopolist. So if we put those things together, that means concentration could promote innovation incentives or deter the innovation incentives, right? Depending on what's the two incentive I just described would dominate. So that's not very convenient for policymakers because we're talking about ambiguous situation. You must say, okay, what the empirical tell us, okay? I just want to talk about two literature. One is literally what's the relationship between innovation and the market structure. The short answer is it's an inverted U relationship, okay? So that means if the market structure is very, very concentrated or is very, very dispersed, you're going to see relatively low level of innovation. In the middle, the innovation will be higher. So that suggests a sweet spot in the middle, but exactly where that spot is may be very industry specific depending on the nature of the technology and so forth. So that's one literature. Another literature is what type of firms are more innovative? Is that big firms more innovative or small firms innovative? People have looked at patents to answer that empirical question. So I'll just sort of give you some summary of the empirical patterns we observed there. First, most small firms do not innovate, at least not innovate in a way that's file patents, okay? But conditional on those who do file patents, the small firms tend to be more innovative in the sense of more patents per worker than in the big firm. Okay, this is probably understandable because big firms may have workers in marketing and distribution rather than in R&D. Okay, so that's number one. Number two is if you look at the quality of the patents filed by small firms or big firms, I think most of the literature would suggest that the small firm patents tends to be more focused, not as widely dispersed in portfolio as compared to big firms, but they tend to have more forward citation. So if you think that's a quality measure, then maybe the quality from small firms in terms of patent might be a little better than the big firms, okay? However, that's on per patent base. If you look at the total amount of R&D expenditure or total counts of patents, the big firms definitely exceed the small firms. So I think Dennis has mentioned that if you just look at dollar R&D expenditure, then all the highly ranked ones are the big firms, very familiar big firms we all have the names in our mind. So that's number three. And number four, which I think it's very important, is it's no longer that we're saying, okay, big firms, small firms, who are innovating more. If you look at today's ecosystem, the two are very intertwined, okay? The big firms may help the small firms to have enough funding, to have the right kind of human talents to do the innovation, or they can compete, or the big firms could be a potential licensor of the technology from the small firms, or could be the potential acquirer of the small firms. So in all these potential interactions, they could be complements to each other in innovation, or they can be competitors to each other in innovation, okay? So just in conclusion, I think all these theoretical literature and empirical literature suggest that market structure is just not a very convenient shortcut for policymakers to conclude which way is best innovation. The bottom line is the policymakers probably have to look into the weeds, especially when we're talking about a very fast-moving, dynamic market, and with the technology involves high fixed costs and probably very low marginal costs. So I'm going to stop here.
Thanks, that was great. Perhaps before we move to the next presentation, I suspect that some of our panelists might want to say something about that, and I forgot to introduce their names. We have Reiko Aoki of the Japan Fair Trade Commission, Koren Wong-Ervin who's a partner at Latham Watkins. John Zhe, sorry, and Marc Ivaldi of Toulouse School of Economics. So does someone want to add something to what Ginger Zhe just said?
On patent?
Sorry?
Maybe say something on patent.
You can say on patent or on innovation, on concentration chokes innovation, or in this case, probably not necessarily.
Okay. Then I will cite two recent papers.
Okay.
There is one paper which is, I think, dated from January 50. And the author is in this room because it's Brian.
Might we even say that this is self-preferencing on the part of this panel to cite that paper?
It's not self-referencing, you know. I'm selling the papers of my colleagues.
So it's more.
Look.
But we can assure everyone that it's not a quid pro quo.
Right. So I think it's a very interesting paper because so it's called Markups and Business Dynamism Across Industries. And so I'm going to be rapid because it's a long paper. But you know, the recent macro trend is rising markups and declining business dynamism. And the common wisdom is that declining business dynamism is due to the high startup markups. And what Brian has done in his paper, so I invite you to read it, is to rebut this argument. So the argument is higher markups is higher market power. Higher market power means lower capacity to enter the market, and so less dynamism. Okay, and what they are doing is really a completely different view. It's even at the end of the paper. The result is that, in fact, there is no evidence that there is a correlation between the two. Okay, so I think it's a very important result. And another paper. This one has been published on January 13 of this year. And it's from Marc, is written by Marc Shankerman and William Matcham. And the title is Screening Proper Right for Innovation. And they have done an incredible dynamic model, empirical dynamic model, to show that looking at the patent screening, taking into account all the incentive of people that are looking at patents, taking into account the intrinsic motivation of these people, the negotiation with the firm. So it's a very complex model. I think what is important is that from this model, they are able to show that the screening, the patent screening, the cost of patent screening for the US is around $25 billion, which is more than 6% of the private research and development. So it's enormous. And the conclusion of the paper is that, in fact, the level, they are able to show that the intrinsic motivation, what makes a patent, our examiners are doing, is it's the main part of this cost. So which means that everything you can do to create extrinsic motivation. So industrial policy, competition is going to be very small compared to that. So the main problem will be more to improve the patent system than everything else. I will just to add comment on what Ginger said.
Okay. Does someone else want to say something about that, or shall we listen to what Richard has to say?
Sure, I'll just, sorry, I didn't know I was on. I agree, and it's helpful to hear the empirics about market structure being, not very helpful way to tell whether a market's innovative. And I think particularly in dynamic markets, I'll talk later about a paper that I wrote with Jorge Padilla and Judge Doug Ginsburg that was actually spurred from a panel that I was on with Phil Marsden back during the pandemic. And I said something about in dynamic markets, the literature talks about how short-run monopoly power is a feature, not a bug, right? You've created an entire new demand curve with a new product. And I think Phil said something like, yes, but the problem is that in many, digital markets, we're not seeing short-run. And so, I think the issue, though, is that in dynamic markets, I still don't think that market structure is a good idea, because I think that if you have this threat of preemptive entry that is conditioning incumbents today, you can have stable and even increasing market shares and still have a lot of innovation and other positive market outcomes.
Okay. So should I take from all of this that if a competition authority is to say in a given case, oh, a firm will exit the market as a result of behavior, that necessarily reduces innovation? Should I be worried about statements like that?
I mean, I guess you're talking about things you can see, right? So I think that some people think a market can't be dynamically competitive unless you see action-reaction, right? Unless you see fluctuations in market shares. And I would say that, if you look at things like R&D expenditure ratios, not just in absolute terms, but normalized by revenues, that can tell you that something's happening, right? That this firm that maybe has a monopoly power by market shares is afraid of the next best thing, of that next leapfrogging innovation. And so it's not so much that we see it today. There's firms that are potential entrants. We have evidence of them. But really, it's there's firms that we may not be able to name or assign positive market shares, but whose presence is felt in the way those incumbents are behaving.
Fantastic. Richard, I believe you want to talk to us about innovation-centric antitrust and the slogan, that's a fantastic slogan, which is creative destruction.
One of my slogans, thanks. Well, first I want to express my gratitude for the invitation to speak at this lovely meeting. I'm also grateful for the fact that the organizers of this conference invited me without knowing what I was going to say. And I'm particularly grateful for the fact that you can't uninvite me after I say it. Now we know that innovation is critical for economic performance, but it's only fairly recently that antitrust enforcers have given any attention whatsoever to innovation. And when they do now, they tend to look at innovation as a complement to static concerns. There was a speech in 2014 by Renata Hesse, a DOJ official, that really encapsulates their approach then and now. She said, "Fortunately, we are rarely forced to choose between preventing higher prices and protecting innovation, because in high-tech markets, a transaction that threatens to lead to higher prices or reduced output will often have a corresponding negative effect on a firm's incentive to innovate." Well, if that's the case, you really don't need an innovation-centric approach to antitrust, because it's just going to be an add-on to a price-centric approach. Where they collide, innovation-centric and price-centric, is when you have a transaction, a merger or conduct, in which there are static harm, such as higher prices, but possible benefits for innovation. And then the question is, how many? You have to choose in that case between protecting short-run versus long-run innovation. And the questions are, how many of these cases are there? And what should antitrust do to actually address them? Now, some scholars believe that these cases abound in the high-tech economy, and you often see citations to Joseph Schumpeter, who famously wrote about perennial gales of creative destruction and also de-emphasizing the importance of traditional price competition. And these scholars, at least some, argue that antitrust enforcement makes systematic errors, often in over-enforcement, because they neglect these in more dynamic Schumpeterian factors. Now, I want to treat creative destruction, as described by Joseph Schumpeter, as a slogan that I propose we de-emphasize in antitrust. Now, I see faces, people saying, this is heresy. How can you say this? This
may not have been the best antitrust room to say that.
That's why I'd say I'm glad you invited me first. This is the dear leader of our movement, so how can we say this? Now, the problem isn't that I don't like creative destruction. I think it's wonderful most of the time. You can, it's not always great, but most of the time. The problem is that in most cases, it's irrelevant to antitrust policy. Creative destruction that occurs at some future date randomly is not something that you have to incorporate in pro-competitive antitrust policy. I mean, suppose there's a 50% chance of creative destruction that occurs in 10 years. Well, and suppose also that it's an exogenous event. It doesn't depend on what you do now. Well, there's no reason then to refrain from enforcement for other reasons in the intervening period. Now, where creative destruction would impact an antitrust enforcement action would be either if it's really imminent, so imminent that the contours of the competitive impacts are going to change, so why even analyze something as it exists today because it's going to change tomorrow, or alternatively, because there's an action, a transaction, or a merger that might make creative destruction either more likely or less likely. And if that's the case, you want to incorporate that in your antitrust analysis. But again, exogenous, just waving your hands and saying, don't worry, there's creative destruction, it's going to cure everything, to me, that has no impact whatsoever on antitrust enforcement. Now, the other thing I want to address is the innovation defense. And it's certainly the case that mergers or conduct such as exclusive dealing arrangements can have pro-competitive effects by promoting innovation, and therefore should be addressed as a possible innovation defense to conduct that might otherwise raise prices. Even Mario Draghi says this. Now, an innovation defense is a form of an efficiency defense, and I want to refer you to one of Professor Hovenkamp's many excellent articles, but this one is on the efficiencies defense and antitrust law. And if I'm quoting Professor Hovenkamp correctly, Herb, you can correct me if I'm wrong, courts are skeptical of an efficiencies defense, particularly in mergers. And when they do acknowledge or consider an efficiency defense, they insist that it be credible, merger-specific for a merger, and that it eliminates the competitive harm at issue. And I want to emphasize the word eliminate. Now, an innovation defense isn't like that. An innovation defense is a balancing of harm and benefit. Harm in the short run from prices, benefit from promoting innovation. This is something that I think courts would have a very hard time dealing with because it does not eliminate the harm. It balances the harm with a benefit that occurs in a future date, possibly even if in a different market, affecting an entirely different group of customers. And I think there's lots of precedents, and again, Herb can correct me if I'm saying it incorrectly, that courts just aren't really going to do this. If they did it, it would be a complicated exercise, even with a bunch of economists that are, employed to do it. Now, if you were going to do this, if you were going to actually get the courts to do an innovation defense, there's another difficulty, which is that courts in merger cases increasingly demand empirical evidence of effects, and empirical evidence that is relevant to this particular transaction that they're studying. So, for example, in a merger of superstores, they might want to look at different geographic markets with or without more or fewer superstores to see what the effects of concentration is on prices and back that into the merger through a econometric diff and diff exercise. That's awfully hard to do with innovation. You don't have innovation that occurs in one geographic market and not in another geographic market in almost any instance that I can think of. So for an innovation defense to really have to have a pivotal role, if you can get courts to consider it in the first place, they're going to have to rely on some kind of empirically based presumptions about how an innovation works, and probably based on transactions that may be similar to, but still different from the transaction at issue. And that's going to require a lot of trust on behalf of the agencies and the courts to do this.
I have questions, or responses, but I suspect that other people do. So maybe, Reiko, I haven't yet given you an opportunity to speak. Maybe you have a response to that. If not, we can circle back to you afterwards and allow other people.
Okay, I just wanted to share some thoughts because I've always been interested in innovation. It's very frustrating that innovation defense is so difficult to convince because innovation is actually part of competition in the long run. So the other way of stating that is this dynamic competition that we're focusing on is a static competition that we're focusing on how do we make the trade-off. And Richard just said, trying to look at similar examples from might be one way to go, and looking at past cases of how innovation happened, I think is definitely the examples, the empirical work that Ginger was citing is very important. I'll just share, but I think the difficulty with innovation is there is uncertainty and you have to try to predict the future. And with that in mind, I'd just like to share one merger review that Jeff DC did that did involve innovation. It was the proposed merger of KLA Tencor Corporation, KT for short, and Lam Research Corporation, LAM for short. And KT is a seller, and Lam is a buyer of inspection tools, and that would be the upstream market. Lam is a seller of semiconductor manufacturing equipment, which is the downstream market. So this merger was a vertical merger, and of course there was the immediate static concern of foreclosure in the upstream market. But we're also concerned about the effect it would have on innovation in the downstream market, or manufacturers who were in competition with Lam in the semiconductor manufacturing market. And we're also concerned that this vertical integration would discourage cooperative innovation between Lam and its competitors and KT. And Lam proposed the merging parties actually proposed a remedy where there will be a firewall of information between KT and Lam's competitors, and also that whenever KT made a new equipment available, it would always be at the same time with Lam and its competitors. But GFTC was concerned that this was not going to be enough to make sure that the necessary potential innovation would actually take place. And eventually the two parties abandoned the merger. And recently, as you know, semiconductor has begun to get another round of special attention in relation to generative AI. And in fact, semiconductor is a very important stack in the generative AI. And we realize now that our decision might have helped to make the innovation in this sector competitive now. And of course, we couldn't have predicted what would happen in the semiconductor industry back in 2018. So I'm just giving you an example of how difficult it is.
Can I say something?
Maybe, well, if it's brief, yes. And then I'll jump to Koren, and then you can.
All right, I'll just leave it with one thing, which is a famous baseball player once said that prediction is hard, especially about the future. And I think you always have to make predictions in a merger case, whether it's innovation or not. And leave it at that.
Well, so if I'm understanding Rich correctly, I think I very much disagree with the idea that in most cases, the creative destruction is irrelevant, right? So what I was talking about before is this threat of preemptive entry conditioning incumbents today? So it doesn't actually matter whether they actually get overtaken in the future. It's that today, are they acting like a lazy monopolist, or are they constrained in some way? Right, and so I think that that one way enforcers can do this is to look at the R&D expenditure ratios, and to look at the nature of the spend. Right, it's important. Is the spend about benefiting products or creating barriers to entry? To look at spend at the product and market level. Right, so for example, is Google's R&D all about making search better, or is it about creating a whole new product? And I think agencies will have access to this non-public information through subpoena powers. So I guess I don't think that it's what we can see. I think it's Jorge Padilla. I've heard him use the analogy of dark matter, this preemptive entry as akin to dark matter, and this idea that you can't understand the universe without understanding that there is dark matter, and that you can't understand competition without understanding and taking into consideration this threat of preemptive innovation, even when we can't name it, right? That's why it's dark matter, but it's still constraining incumbents today.
So since we have a feisty disagreement, I have to respond.
Yes.
So look, I'm not saying that creative destruction isn't important. It certainly is, and you have Andy Grove, only the paranoid survive. Apparently, Intel wasn't paranoid enough because they're not surviving these days. The issue is if you have a transaction or a merger, so a transaction, say an exclusive dealing arrangement, then the question is it relevant that 10 years from now there could be a cataclysmic creative destruction event that would change the market? I would say not really. I mean, you got 10 years to worry about, and during that 10 years, you want to think about the same kind of things that you would think about without the creative destruction. I'm not saying that creative destruction is something we should ignore. It's just that for that particular enforcement decision, I don't see how it's relevant.
Anyone else wants to add something?
Yeah.
Sorry, Ginger.
Maybe I can make a comment about Richard's discussion. I think you mostly thinking about a trade-off between price and innovation. I think at least in some recent cases, we have seen the trade-off is one type of innovation versus the other. So for example, if the policymaker is saying that some incumbent have to share their assets with current and future competitors, it's probably going to encourage the competitors to do innovation because now they have free assets to use or very low price assets to use. But on the other hand, you have to question what's the incentive of the next Google or next Apple to invest in such assets if they know that in the future they will be compulsory to share such assets. So I think it's a trade-off between sort of the competitor innovation today upon the free sharing of assets versus tomorrow's incentive investing maybe the next round of creative destruction.
Well, that's what intellectual property policy is explicitly about, that trade-off. The fact that we have 20-year from date of discovery or whatever it is for a patent term is a trade-off between the price effects and the incentive effects, as well as whatever compulsory licensing requirements we have.
I do want to sort of shift gears to a couple of other topics, but I think we can at least agree that there are some questions. The first one that I think we could add is what you say about maybe a future company. The effects of policy today may affect the likelihood that a new Google will enter the market. I think there's also a question of, does it affect a Google's incentives to innovate today? That is one question. I think there's also, if I got it correctly, a question of at what level of granularity in antitrust should we be thinking about innovation? Do we need to think of it at a very granular level with an innovation defense, or should it be, I think that's more the direction in which you're going, which is, well, we maximize competition enforcement today, we focus on what we know, and then we leave it. If you have,
it's a little related to the prediction issue. And I just as I give the creative discretion people a hard time, I also give people a hard time who say we cannot predict innovation. I think we actually can. I think there are a number of structural conditions about a market in which you can make fairly reliable predictions about what's going to happen. Taking into account the fact that even conventional price-centric merger policy involves a lot of guesses about the future too. So it's not impossible to predict, and I think we should try to do it. Getting courts to actually rely on those principles for prediction is a whole other story.
I'll give Marc le dernier mot on this issue, and then we'll move on.
Le dernier mot, okay. And I will try maybe to go further. Well, predicting innovation seems to me quite difficult. I have always this example of the case on carton pack for liquid orange, and so Tetra Pak wanted to buy Sidel because Sidel was producing, was able to mold a plastic bottle. And apparently, consumer prefer plastic bottle because they see the product inside, the orange juice, the Coca-Cola. And to make the story quick, so it went to the European court, and the big discussion was to know whether they will be able to put milk in plastic bottle. Okay, and you can see right now that you can have milk in plastic bottle, but on fresh milk. You cannot buy milk in plastic, transparent plastic bottle that can stay for a long time. We are still opaque bottle, okay? And the whole discussion was whether it was possible to do that. So at the end of the day, the decision has been completely wrong because Tetra Pak and Sidel did not succeed to provide that. So it's very difficult. So I think that the good way is more to to consider whether there are a possibility of investment, and whether, when we look at an industry, we can take into account the dynamics. I think that the dynamic competition affects all markets and all type of industry. There is no, as soon as, for example, a tomato producer wants to have some market share in the future, you have a dynamics. Pharmaceutical market are dynamic, but also rail freight are dynamic. For what reason? Because if you don't invest in the maintenance of track, in the future track are decaying, so you will reduce speed, so you will take more time, so shippers will be unhappy, and you won't be able to. So there is this tension, and we have done since 20 years an incredible progress in analyzing this type of model with data. So we are able now to measure static efficiency, that is to say, whether it is better to have more competitors, but if we have more competitors and lower price, we will have lower income in the future, lower investment, we will not be able to maintain the track and to make innovation. Okay? Yeah. And so dynamic efficiency. The problem is why it is not done, why it is not used in competition policy, why this type of progress in economic analysis is not used by agency, by competition authority, by consultancy, by firms. I'm very surprised that it's not used, but we can go.
Okay, I guess a related topic is like we see politicians and policymakers at least express a desire to promote innovation and competitiveness. And we've talked now about competition policy or competition enforcement as a tool, but there have been other tools that have been suggested or put forward for states or governments to maximize innovation within their jurisdictions. One of them has been the passing of ex-ante competition regulations, and other suggestions have also been about use of industrial policy to boost innovation in a given jurisdiction. And I was wondering who on this panel had thoughts about the...
Yeah. Well, on the two questions, on the question of regulation, so in fact, the two papers the papers that I was speaking about, Marc is a part of that. And I think in terms, it's a paper of Marc is showing that we need to boost to boost innovation. We need to do something because it is there is a lack, in fact, of innovation because of the process. But I think that we were speaking about that over dinner. The problem of doing regulation for innovation is to create the good condition for that. Okay, and it's important, for example, to see the difference between the US and the EU on this question. I think one of the big difference is related to the discussion on the Draghi's report is the cost of failure. The cost of failure is much higher, or is perceived much higher in Europe than in the US. Okay, so everything that could change that is going to be important. It is higher because of cultural reason. We are not educating our kids in the same way. There are political reasons. Main reason it's a conjecture that we are giving much more focus on the defense of the providential welfare state than maybe in the US. Is there a relation? Nobody has proved it. It's a conjecture, but that happens. So that I think it's a very important point. The second point is on industrial policy, I will say. Okay. So on industrial policy, so I was listening to my colleague Paul. I think that. In France, we have been very good on that. We have been putting 5 billion euros to develop the French Google. So we know about industrial policy. Well, we know about bad industrial policy. So the question is how to do good industrial policy. And I think that, the industrial policy is the only reason for industrial policy. From an economic perspective, is when there is a market failure. Market failure exists, and so we have to identify a market failure. The problem is how to implement after. And what it is important, and the North World example is good. I think that it is precisely the process of implementing industrial policies that it can be bad. The good way will be, although it's linked to the contract theory, we don't know. So we can, as soon as we have solved this problem of financing and we have all this money, we can decide, we need battery in Europe. Let's make a bid for a firm to produce battery in Europe. So they can choose their location, not in the north of Sweden because there is nobody there. They can decide, okay? And so they can decide about the amount of subsidies they are asking and all those things. We can do it. And so I think that it is what we should implement. But it doesn't solve all the problem. It's maybe related to a question that Dirk is going to ask. If you organize this bid and then a Chinese firm wins the bid, did we solve the problem?
Yeah, that's a good. I think we can get to that in a second, but I've got some.
About industrial policy.
Industrial policy, regulation.
Okay,
whatever
first industrial policy. Okay, because I come from a country of tradition of industrial policy, and actually the Draghi report, when I read it, it sounds exactly like what's being said in Japan right now. That it's falling behind. We are dependent too much on manufacturing. We have not been able to switch the workforce or the technology innovation in the right direction, and we need to do something about it. And I think, in that sense, industrial policy that we were talking about over lunch, in fact, that it's not just looking at a particular market, but it's looking at everything that would promote some kind of advance and improvement in productivity. And so for that reason, it would include things like the labor markets and the capital markets as well. And in fact, when you read Arrow's book on uncertainty, where he talked about, that started the whole debate about market structure with Schumpeter. Arrow points out that if it doesn't matter, the size of the firm probably would not matter if the capital markets were perfect. It's when you have to invest your own profits into innovation that the size or the profitability is going to matter. So one way to promote innovation, and part of it, industry policy to do that, is to make sure the capital market is functioning properly. And in many countries, there is a special agency for overseeing that. But in Japan, and I'm sure in many other countries, there can be competition issues over bid rigging and so forth, that the Antitrust Authority can intervene into. And I think it's the same thing with labor markets. One of the reasons that the workers are not shifting to the new industry is because the labor market's not functioning smoothly, and that could be sometimes a competition issue, that there are some unfair, unreasonable contracts between the employee and the employer that would prevent efficient movement of labor. And this relates to market failure that Marc alluded to about coordination. We found that in Japan, in order to, and I think it's true in all countries, in order to promote EV, you need the charging stations. And in many countries, including Japan, it used to be a government-led project that didn't expect markets to work properly. But to make it sustainable, you need to have the charging station be profitable, like gas stations. Nobody thinks the government should be in the business of providing gasoline. And we found that the incumbents that were subsidized by the government to begin with were very reluctant to give up the market to competition. And that's exactly a competition. We were surprised that when we shared what we did about the EV charging market, there are other countries, I think Portugal and also Spain, and that the antitrust authorities actually had to go into the electric car charging market to make sure that it would allow for new entry. So industrial policy should be taken in a bigger scope than they usually are, and also it's antitrust. There's room for antitrust engagement.
If there are any very brief responses to this on the panel, because I do want to leave time for audience questions.
Sure, I'll just say there's a nice paper by former FTC Commissioner Christine Wilson and Keith Clovers that talk about some of the lessons to be learned about regulation in the U.S. and the airlines and railroads, some line of business and structural separations, and how after deregulation, there was much more innovation, lower prices, increased output. And so I think to learn from those lessons when we're considering self-preferencing and other prohibitions. The other thing I'll say on industrial policy is that for me, I wouldn't have it in antitrust. I think we should be pure. I think antitrust enforcers are probably ill-equipped. How do you weigh and balance? Well, we have price increase here, but do you flip a coin, or how do you weigh and balance those things? I do think if you have it, that democratically elected officials can, have policies and just be transparent about it. Mm-hmm. So my understanding in the U.S., I could get this wrong, but I think Tad Lipsky told me this story about when Reagan was president, the DOJ antitrust had a case, maybe price fixing in the airlines industry, and Reagan said, we are just now with the UK, deregulating the airlines and, to hold off. And so there was a press release that went out that said, we think there's a problem here, but because there's, they serve at the pleasure of the president, where there's something else going on here. And it was transparent.
One tiny question in the audience, and we've spoken about antitrust as a lever for innovation. We've spoken about industrial policy, regulation. There's one other aspect that I perceive happening more often is enforcers trying to enforce their local rules, but influence how firms behave abroad. So I can give an example. It would be like a decider in one jurisdiction setting standard essential patent rates globally. And so you could say maybe arguably the same thing happens when a competition authority looks at a merger and realizes that if they block it, it will have effects in other jurisdictions. I don't know if someone has thoughts about this trend, about whether, does that change the cost-benefit analysis of regulation? Does it change whether we should be regulating? Is it a risk also? Is there a risk of capture there?
It's not a small question.
No, it's right. Time is limited, but I did want to broach the topic.
It's very complicated. I think it depends on the situation. Clearly, regulations in one jurisdiction have both direct effects on the interest in regulation in other jurisdictions, and indirect effects as well by changing how competition takes place between products from or related services in different jurisdictions. So.
Yeah, Does it at least, I don't know, undermine the idea that sort of regulatory competition can fix the risk of overregulation? Is that?
It can be raced to the bottom.
Yeah.
Well, I mean, on the west side of this question will be to say we'll need, for example, an international competition authority. Well,
there is one. I don't know how effective it is.
It's apparently what is working more.
There have been attempts to collaborate more across the Atlantic on competition policy, but maybe that's a can of worms we don't want to open.
I think that the soft power, I mean, soft relation, the role of OECD, so Frederick has run for a long time. I mean, there is a diffusion. It's not necessary that there is a direct impact. We will see that how the DMA is going to affect what the US are going to do directly. It's difficult to say. Indirectly, there are influence. There are clearly, we see that on the regulation of digital market, it affects in different ways. Even China, for example, is putting in a different political context. Okay, so there is an impact. What is important here is also the role of the extraterritoriality rights that some countries have. That could effectively have an impact, and indeed it is one of the big issue right now in Europe.
Maybe we can have some audience questions. Francisco, you might not even need a microphone. You have a very long.
No, I think you probably the problem is you were framing the question in too abstract terms. The idea now is with the DMA, Apple may be changed to change the business model, maybe forced to change their business model. So I guess you were asking whether that would mean that Apple would have less incentives to innovate in the rest of the world. Is it feasible to understand that they would isolate continents for how they develop their products? I don't know.
Yeah.
Maybe.
But you have first to prove that DMA is going to give the good incentive to innovate.
Well, if they force Apple to open their through making it interoperable, to open their closed system, would this mean that Apple would have less incentives to innovate, to invest less in innovation? You are the smart guys, the economists. Tell us.
Well, now we have natural experiments. Like I think some countries should sort of take a wait and see approach. Where it's too early yet to do the natural experiments, but like we'll have them with the DMA. We're starting to hear some anecdotal evidence of harm from airlines, from hotels, that they're being harmed, their revenues, from the remedies that are required of Google search, that's favoring large aggregators. But those are anecdotal, and I'll just disclose I do work for Google.
The cost benefit of implementing DMA has not been down. Yeah. So it's very difficult to tell you, even in Europe. So you are asking economists to reply. The problem, at least academic economists, I'm not sure that we are able to have access to the data to answer your question also. So, but from a pure liberal approach, if the firms have set up a business model and it's profitable, and people are happy, it's very difficult to. But I'm not saying that we should not regulate, and there is too much market use of market power. It's not that. So the problem is to evaluate the impact in terms of growth and economy.
I think Reiko was going to say something.
Can I just say, since you mentioned regulatory capture, I thought you did anyway. So with the DMA, well, and Japan itself has a version we call the mini DMA that looks at, which is regulation of the mobile OS. And one thing that I noticed that we always talk about regulatory capture, but in case of these digital platforms, there are actually two sides, right? There's the consumer side, and then there are the other vendors. In case of of retailing, and in case of phones, there's many people who make the app or other content for the digital platforms. And they're one of the players that potentially can capture the regulator. And one thing that's happening now is the regulator trying to determine the split of surplus between the digital platform and one side of the market. And consumers perhaps are getting ignored. And I think it was Kenneth in the morning that said, we're the enforcer, the only people who are standing up for the consumers. And I think, yes, that's so true. And we need to keep an eye in terms of what exactly is the DMA and these regulatory platform regulations doing, how much the consumer is actually benefiting. It's something that's, you could take note.
Yeah, I just want to make one comment to Francisco's question. I mean, indeed, it's hard to predict how Apple going to change its innovation in response to whatever DMA requires it to do. But on the other hand, Apple can also decide what type of old and new products will be offered to EU as compared to the rest of the world. So I think these both dimensions could be important if we're thinking about EU citizens' interest, right?
I'd also add, though, that there could be innovation other than Apple, and it would be an interesting experiment to see what happens.
Mm-hmm. This just harkens back to the beginning of the panel, but is the inverted U dead now? Do we not believe in it anymore? Does it have any relevance for antitrust policy or any other kind of policy for that matter? I remember Philippe's pictures were statistically quite thick, and they appeared to show an inverted U relationship between market concentration and innovation.
I can take a stab at it if you want.
I think, yeah, you, Ginger, definitely.
I think the empirical evidence of the inverted U is certainly not overwhelming. There is one thing that I find interesting, which is that if you look at the effects of entry on innovation, it's very different for frontier firms than it is for laggard firms. And that difference is consistent with the factors that create an inverted U. And that is some empirical evidence that's pretty strong.
We're never going to come up with an HHI equivalent to measure
No.
Hold on.
a metric for relating market concentration to innovation prospects.
Yeah, but I don't think, the kinds of market structures where you would have actually an innovation enforcement basis would be highly concentrated markets, far from any inverted U story. And you would have, in my opinion, very strong legacy effects that create arrow disincentives. Those are very important.
Just a quick word on this inverted U. I contributed to this with one paper a long time ago, about 20 years ago, and one thing I am aware of is that it's highly sensitive to aggregation effects. So, particularly if you have over time changes in types of activity that are making up your innovation ecosystem, then the inverted U may not hold simply because the proportions of the different kinds of activities are changing over time. So my own view was that this was a descriptive result of some interest back in the 2000s, the early 2000s, but that it has absolutely no structural validity for basing any kind of policy intervention on.
Yeah.
I'd almost agree.
Any other questions? Oh.
Brian, I'm sorry, how could I miss?
I appreciate Richard's pushing back on the cliche of creative destruction, the Jedi mind trick of creative destruction, wave away the concerns. But my second reaction was, what if we think about error cost frameworks, chance of making a mistake? Does it have a role then, creative destruction? The idea if we let a merger through, well, creative destruction will overtake it. Or does it flip the other way? We block a merger that we maybe shouldn't have, well, creative destruction will, come in and supplant it anyway, so we don't really need to concern ourselves with it. Like, if we take creative destruction and the fact that regulators make errors, I hear sometimes they make some mistakes, does that kind of tip us one way or the other?
I think that's a good question. I think the answer depends upon how likely it is in the future. I mean, if the creative destruction is 20 years off, I would say probably not very important one way or the other. The other thing the other seed I would plant is just that, there's type 1 and type 2 errors. And creative destruction might fix type 1 errors, it doesn't fix type 2 errors, under enforcement.
Can we finish with, I'll ask one last question. It's a surprise question for everyone on the panel. They have not prepared this. And you can only answer extremely briefly. If there is one policy change that you could implement today to increase innovation, what would that be? Any?
Whoa.
You can choose one. It doesn't have to be perfect, but it has to be your favorite.
I think that clearly in many markets, what is important is in fact to in particular in innovation, to call for firms that are able to do the innovation. Okay. So I think that one of the problem is to implement good auction system, okay, so the policy change will be use auction and contract, use the contract theory, use what we know about auction to improve public policy.
Okay.
So I think antitrust policy is probably not at the top of the list in terms of promoting innovation one way or the other. I do think you need more government support for innovation and patent reform because our patent system is a mess.
I'll focus on antitrust, which is what I know. I'll just mention in the paper that I mentioned earlier with Jorge Padilla and Judge Ginsburg, which we didn't get to, but I'm happy to talk about with anyone. We really are encouraging agencies to look at R&D expenditure, to look at the evolution of it over time in order to determine whether a market is dynamically competitive and whether that threat of preemptive innovation and entry is constraining it, conditioning incumbents today.
This is about Japan, but I changed how the regulations stated. In Japan, the regulation says things that you're allowed to do, for instance, additives that you're allowed to use, whereas in the United States, and I don't know what it is in Europe, you list the things you're not supposed to do. So as long as you don't do the things you're not supposed to do, you can do anything as long as you're willing to face the consequences. But when you're only going to do the things you're allowed to do, you have a positive list, then innovators wait around until a law is passed making that thing legal, and it slows down innovation. So I changed that.
It's hard to be the last. I feel like whether antitrust agency or other agencies often lagged behind the market. So I would say no matter what agency we're talking about, they need to learn about the market, catch up with the market, to really understand, for example, how venture investors decide which project to invest, which project not to invest, what the market forces determine the innovation dynamics. I feel like that's the foundation before they try to trial and error with new policies.
So they should do good empirical economic analysis.
We need more economists in business schools. And on that bombshell,
Exactly.
we're done.
Very good. Thank you. Please thank our panel.